£35,000 rent arrears, an unpaid universal credit claim, tenant evicted. At first glance, this may appear to be a straightforward possession claim. The tenant fell into arrears, the landlord served a Section 8 notice, the case went to court and possession was granted. This case took place before the Renters' Rights Act changed the mandatory Ground 8 rent arrears provisions. At the time, the court could take all rent arrears into account when considering the claim. Under the new legislation, however, the court must disregard any arrears that arose solely because the tenant had not yet received universal credit payments they were entitled to receive. If a similar case arose today, a private landlord would first need to establish whether any of the rent arrears resulted solely from delays in the tenant receiving universal credit payments they were entitled to. That could now be a crucial factor in determining whether the mandatory Section 8 Ground 8 threshold has been met. This case provides a useful opportunity to examine how a private landlord responded when a tenancy began to unravel following a relationship breakdown. As the circumstances changed, the tenant's universal credit claim was affected, and significant rent arrears eventually accrued, reaching around £35,000. It demonstrates how changes in personal circumstances can have a wider impact on rent payments, and highlights the importance of identifying those issues at an early stage, discussing them with the tenant, and considering whether further support or signposting may help prevent rent arrears from escalating. Before we continue, it's important to explain that this is an example case study. It combines elements from real possession cases and other real universal credit situations to demonstrate how relationship breakdown, joint universal credit claims, rent arrears and possession proceedings can interact in practice. The purpose is to explain the practical issues. The couple were joint tenants and joint universal credit claimants. At the time, the housing element covered their rent. Following the breakdown of their relationship, one tenant moved out and the joint universal credit claim came to an end. The remaining tenant stayed in the property, but the housing element payments towards the rent also stopped. The court judgment does not set out the full details of the universal credit claim. However, it provides a useful opportunity to consider some of the issues that private landlords may encounter following changes in a tenant's circumstances. Understanding those issues can help landlords review their rent arrears procedures, identify potential problems at an early stage, and consider whether appropriate discussions or signposting may help prevent rent arrears from escalating. The case was heard at a county court in the summer of 2025. The tenant had accumulated around £35,000 in rent arrears. The landlord relied on Section 8 Ground 8 of the Housing Act 1988. Rent arrears mandatory ground for possession. Once the legal requirements were satisfied, the court had no discretion. That was the legal position then. But for today's landlords, the more important question is this: how did those arrears reach £35,000 in the first place? Relationship breakdown can have a significant impact on a household's financial circumstances, particularly where rent is being met through a joint income or a joint universal credit claim. Research published in April 2026 by the University of Bristol Personal Finance Research Centre and the Centre for Homelessness Impact identified relationship breakdown as an important trigger for problem debt, highlighting how sudden changes in household finances can contribute to rent arrears and increase the risk of homelessness. This provides useful context for understanding how changes in a tenant's circumstances can quickly develop into a rent arrears case. And unless the right advice is obtained early, relatively manageable problems can quickly escalate. According to the information available, the tenants had identifiable vulnerabilities, and much of the communication was undertaken through their adult children, who advocated on their behalf. That is simply part of the background to the case, but it illustrates how additional support needs can make an already complicated situation even more challenging. Following the relationship breakdown, the remaining tenant needed to notify the DWP of their change in circumstances, including the change to the joint tenancy and household arrangements. It was the claimant's responsibility to provide enough information for the DWP to assess the change and determine, on the balance of probabilities, that the other joint tenant had left the property and was not expected to return. That evidence did not necessarily have to be extensive. A claimant's own account could be accepted, provided it was credible, consistent, and not inherently improbable or self-contradictory. This is because universal credit decision-makers determine claims on the balance of probabilities rather than the higher criminal standard of proof beyond reasonable doubt. Guidance explaining the operational process for T-work coaches and case managers are reminded that they must not ask the claimant to redeclare housing costs as a single tenancy, make a housing declaration on behalf of the claimant, or ask the claimant to get a new tenancy from their landlord or a landlord letter. Examples of the supporting information the remaining tenant may be able to provide include a copy of the departing partner's new tenancy agreement or a letter from their new landlord or local authority, where this is available. Official correspondence, such as letters from HMRC, the DWP or a GP, showing the departing partner is registered at a different address. The Department for Work and Pensions has guidance for situations where one joint tenant leaves but another remains in occupation. Where one joint tenant has permanently left the property, commonly known as an untidy tenancy or absent joint tenant cases, the remaining tenant should be aware that the relevant rules are contained in Schedule 4 of the Universal Credit Regulations 2013, which governs the housing costs element for renters. Under Paragraph 2 of Schedule 4, a claimant may qualify for the housing costs element, where they are liable to pay rent and occupy the property as their home. In a joint tenancy, the remaining tenant is still legally responsible for the rent because joint tenants are jointly and severally liable. That liability already exists under the original tenancy agreement and does not depend on a new tenancy being issued. If the Department for Work and Pensions insists that a new tenancy agreement is required before paying the full housing costs element, the claimant can ask for the decision to be reconsidered. Under Paragraph 35(5) of Schedule 4 of the Universal Credit Regulations 2013, the DWP has discretion to depart from an equal 50-50 split, where it would be unreasonable to do so, and can instead award the proportion it considers appropriate. A claimant could therefore explain, "My joint tenant has permanently left the property," creating what is commonly referred to as an untidy tenancy. As the remaining joint tenant, I remain jointly and severally liable for 100% of the contractual rent. If the full rent is not paid, my landlord may take possession proceedings against me alone. I am therefore requesting that my housing costs are manually reviewed under Paragraph 35(5) of Schedule 4 of the Universal Credit Regulations 2013, and that the DWP considers awarding 100% of the eligible housing costs. Please use the Record a Change in Joint Tenancy Costs process to manually review my claim without requiring a new tenancy agreement. Why is that important? Where both the landlord and the remaining tenant understand the relevant regulations and the evidence required, the correct housing costs are more likely to be awarded at an early stage. This can minimize avoidable rent arrears, support tenancy sustainment, and reduce the risk of possession proceedings where the tenancy is otherwise sustainable. Understanding the relevant regulations and the information that may be required can help claimants navigate the process more effectively where a joint tenancy has become an untidy tenancy. As with any universal credit decision, each case will rely on its own facts, evidence, and individual circumstances. Where appropriate, claimants should seek independent advice or specialist welfare benefits advice at the earliest opportunity to ensure they receive advice tailored to their individual circumstances. The abolition of Section 21 has fundamentally changed the legal landscape for possession claims. Where landlords rely on Ground 8, the mandatory rent arrears ground, understanding how the Renters' Rights Act treats rent arrears arising from universal credit housing costs has become an important consideration. Where the Renters' Rights Act requires universal credit-related rent arrears to be disregarded, those arrears cannot be relied upon for the purposes of a mandatory Ground 8 possession claim. This represents a significant change for landlords, tenants and advisors, and reinforces the importance of identifying housing costs issues and resolving them at the earliest opportunity. For landlords, early intervention, understanding why arrears have accrued, and signposting tenants to independent welfare benefits or housing advice may help prevent avoidable rent arrears from escalating into possession proceedings. For tenants, understanding the relevant regulations, providing the appropriate supporting information and acting promptly may help protect their housing costs, reduce avoidable rent arrears, and improve the prospects of sustaining their tenancy. Ultimately, this case demonstrates that resolving universal credit housing costs is no longer just a welfare benefits issue. In the post-Section 21 landscape, it has become an important part of effective tenancy management, rent recovery and possession proceedings.